plaintiffs' lawyers have incredible networks of information and flow about what negotiating strategies are being used by big companies.
Right.
Word gets around, and if you're known as a soft touch on settlement, you'll just pay and pay and pay and pay.
Right.
And many big fine companies have gone under by virtue of just becoming a bank for the plaintiff's bar.
Right.
So it's a long way of saying that you've got to make a risk assessment. You've got to live within your risk assessment. And many lawyers are not willing to help a client make that risk assessment. They would rather just say, well, nobody knows what a jury's going to do,
right.
which is true. And we could lose this case, which is always true. And if we lose it, it could just blow the doors off the courthouse, which is also true.
Right.
In my experience, if we properly and reasonably assess the risk, and we made our prognostication and we got ready for trial and we did a good job with the case we had and we didn't lose our poise, I never had the doors blown off of the courthouse by a case that I had worked up and we properly assessed. It happens, there are occasional devastating verdicts, but far and away they're the exception, and they're not that common, thank goodness.
Being a trial lawyer is risky. It's like, you know, climbing a rock face.
Yeah.
You got to have the guts to climb that face.
Right, and you look down and you say, wow.
That.
You look at an adverse verdict and you go, wow, I don't want to do that. I don't want to go there.
Right.
So in contrast to the settlement lawyers, my many good friends and colleagues who are settlement lawyers, you have the trial lawyers. And that's what we're going to talk about next. An entirely different breed of cat.